is Paul. Yeah. It's 3:45. I just got here. And I'll probably use the room for an hour and 15 minutes and then maybe go to dinner. Yeah. Then return and then give myself an additional 45 minutes after dinner. Yes. Now, I had sent about 2,000 emails this afternoon. There's an organization that is concerned about civil rights, humanitarian rights, and predominantly they were concerned about gay and lesbian and transgender rights. But my concern was the actual civil rights of American citizens. I don't know if you got that email or not, but the whole concept of depriving a person the lawful use of any and all federal facilities known as courthouses, yeah, without calling them and putting it in publication and saying that you mailed the notice of the hearing. Yes. And then there's that big question, well, is it a wrongful execution of a court order if on or before the next day you don't attempt service on the respondent? I think it is. And I think it violates numerous hate laws. Now, I would like the availability of using anything that is paid for from state or federal taxation, yes, without concern that somebody's going to harass me or intimidate me for wanting what every American citizen has the right to use. Now, I didn't get any phone calls, and I thought possibly you didn't understand. Now, yesterday I had talked about this, but the knowledge of my not being in Sequim, Washington on December 3rd of 2015, yeah, and then refusing to admit the evidence of my innocence is a hate crime in violation of all federal and state funded institutions that every class of person has the right to use. Now, the calling of myself on the phone when serving the notice of the court hearing in 2013, when you had put it in publication and you said that you had attempted to mail me the notice of the court hearing. Yeah. I was looking at this, and I'm more and more convinced that it was intimidation, that somebody was going to teach me a lesson. Now, when you really look at the chronological, yes, case resolution closed by court order after hearing, yes, order issuing temporary protection order, then motion hearing, sheriff's return of service, sheriff's return of service. I know I have the other part of that someplace here. Yeah. Um, the concept of you not having to enforce the actual laws of the United States because you just don't want to get impeached for treason really doesn't concern me. Now, petition to motion to modify, right? And then sheriff's return of service, notice of hearing, 7-5, right? Sheriff's return of service, order reissuing temporary protection order, motion hearing, proof of mailing, declaration of Heidi Budnick. Oh. She declared that she had sent the notice of the court hearing, and it is mail or publication. Yeah. And then the sheriff's department, called me on the phone, right? And then you did not attempt service after the court hearing on before the next court date. Yes. Sheriff's return to service, order reissuing, proof of mailing. Declaration of Heidi Budnick, return of service. Declaration of Heidi Budnick, undeliverable mail. Sheriff's return, order for a 2-year protection order. Motion hearing, Brent Based. And then from August 30th of 2013 until November 8th of 2013, there was no attempt of service. Now, I've kind of gotten familiar with reading these court orders, and it says here, yes, um, that the Sheriff's Department on or before the next judicial day, here it is, service. The clerk of the court shall also forward a copy of this order on or before the next judicial day to the Clallam County Sheriff's Office, where respondent lives. Now, yesterday I went over that the respondent must know the restraint provisions and when it expires. Now, you intentionally put it in the newspaper. You say that you attempted to send it to me, and the Sheriff's Department intentionally called me to personally serve me before the court hearing so that I would understand that my presence wasn't wanted there. But when it's on or before the next judicial day, and it was November 8th that you returned the service not served, it should have been the first week of September. Now, you really fucked me, didn't you? You really did. Are you feeling good about yourself, Sheriff? Now, this was issued for 2 years. I told you that you reissued the temporary protection order on June 1st of 2015 before the 90 days of expiration. It's obvious that it's illegal. And yet I don't get a phone call or an email about why it is that I'm deprived of my sons. Now, you could not reissue it because it did not expire until 8/31st of 2015. It was effective for exactly 2 full years. Yes. Date of expiration would have been August 31st of 2015. Now, there is a question about the petitioner. She did not motion the court to have you reissue the temporary protection order, did she? Is that why she said, well, I'm not signing this? Because there is no signature of the petitioner. There was no attempt of service between June 1st of 2015 and June 12th of 2015. You attempted service after June 12th of 2015, and you had scheduled order reissuing temporary protection order. Right. Motion hearing. Now, on the public record, it says the actual date that you had scheduled the court hearing. Let me see here. I think it was July 31st of 2015. Exactly how long can you issue an ex parte order for protection? As I understand it, it's 14 days. But when I did the calculation, you decided to have the permanent court hearing 50 days later. Now, for some reason, you think that you don't have to enforce the law. Why in the fucking world would you think that you don't have to enforce the fucking law?